House will come to order. As Speaker of the 117th General Assembly, I hereby call this joint session to order for the purpose of receiving the Chief Justice's State of the Judiciary address. I have the honor and privilege again to have what I call the worst job in any political environment, and that is in introducing a large number of people. I used to kid in my home turf that they would give this job at a large political function and the next person they wanted out. Because you have a 100% expectation of doing it perfectly. If you do that, you've just met expectations. You are bound to butcher several, as I did last evening, and I'll try to fix those tonight. First, we're joined by the honored Chief Executive of the State of Indiana, Governor Mitch Daniels. Governor Daniels. To my left is the Lieutenant Governor of our state, Becky Skillman. We're joined today by the President pro tempore of the Indiana Senate, Senator David Long. Also on the majority leadership team in the Senate floor leader, Senator Connie Lawson. We're also joined by the minority leader in the Senate, who will be with us apparently in a few moments, Senator Vi Simpson. Senator Simpson. And the assistant minority leader in the Senate, Tim Lannon. Senator Lannon. And I extended my apologies for last evening, Tim, before you arrived. And the Minority Caucus Chair, Senator Jim Arnold. In the House leadership, we have the Majority Floor Leader, Representative Bill Friend. Majority Caucus Chair, Kathy Richardson. And the Speaker pro tempore, Representative Eric Turner. The Minority Leader in the Indiana House, Representative Pat Bauer. Minority Floor Leader, Representative Linda Lawson. And in the back of the room, the Minority Caucus Chair, Representative Dale Grubb. We're also joined by a large number of guests today, and we're honored to have their presence. First, Amy McDonald, the wife of the Chief Justice. And a young lady who's grown up before our eyes in this chamber on this date, Maddie Shepard, the daughter of the Chief Justice. And Maddie, I'm sure you're thrilled to know that I believe the first time we saw you, they carried you in. We're also joined by Jan Dixon, the wife of Chief Justice, or of Justice Brent Dixon. And Denise Rucker, the wife of Justice Robert Rucker. And Catherine Pulley, the wife of Justice Stephen David. Welcome. We have our tax court judge-elect, Martha Wentworth. We're again joined by our many of our statewide elected officials. First, the Chief Attorney for the state, Attorney General Greg Zeller. Our Auditor of State, Tim Berry. And our Secretary of State, Charles White. And representing Treasurer Richard Murdoch, Jim Holden, the Chief Deputy and General Counsel to the Treasurer. And representing Superintendent Tony Bennett, Becky Bowman, the General Counsel to the Superintendent. We're joined by Dr. Linda Bennett, the President of the University of Southern Indiana. or not, and by Adrian Meyring, the counsel to the Judicial Qualification Commission. We have several members of the Indiana Judicial Qualifications Commission with us: Jim McDonald, Christine Keck, Fred McCashlin, and Bill Winningham. We're also joined by Jeff Lind, the president of the Indiana State Bar Association. Christine Hickey, the president of the Indianapolis Bar Association. And Eric Chickadance, the president-elect of the Indiana State Bar Association. And finally, Michael Hebenstreet, the president-elect of the Indianapolis Bar Association. We also have with us a former Supreme Court Justice, former Justice Theodore Boehm. Justice Boehm. Ted, once you're out, everybody loves you. At this time, would the Chief Justice and the legislative escorts and the judges of the Indiana Appellate and Tax Courts please come forward? The judges are escorted by Representatives Ralph Foley, Greg Stierwald, Representative Gail Rieken, Representative Matt Pierce, Representative Michael Young, Greg Walker, Greg Taylor, and Karen Talion. Well, the cardinal rule in politics is never to make your entrance longer than the natural applause. We do not have a political judiciary. It's my high honor as a member of the bar to introduce the esteemed members of our Supreme Court in the Indiana Court of Appeals. The Supreme Court justices with us are Justice Brent Dixon. Justice Dixon. Justice Frank Sullivan, Jr., Justice Sullivan. Justice Robert Rucker, Justice Rucker. And the newly appointed member of the Supreme Court, Justice Stephen David, Justice David. With the Indiana Court of Appeals, we have again with us our new Chief Judge, Judge Margaret Robb. The former Chief Judge, John Baker. Judge Edward Najam, Jr. Judge Ezra Friedlander. Judge Patricia Riley. Judge Carr Darden. Judge Mark Bailey. Judge Melissa May. Correctly pronounced, Judge Nancy Vadic. Judge Paul Mathias. Judge Michael Barnes. Judge Terry Crone. Judge Cale Bradford. And Judge Elaine Brown. And from the Indiana Tax Court, Judge Thomas Fisher. And it's my high honor to present to you Lieutenant Governor Becky Skillman.
Members of the Joint Assembly, pursuant to Section 3 of Article 7 of the Constitution of the State of Indiana, this joint session of the two houses of the Indiana General Assembly is now convened for the purpose of hearing a message from the Chief Justice of the Supreme Court of the State of Indiana. It is my privilege to present to you the distinguished Chief Justice of the Supreme Court, the Honorable Randall T. Shepard.
Thank you all very much. Thank you. Thank you all very much. Thank you all so very much. Now, one of the features of our national dialogue last summer and fall was skepticism about the competence of public institutions and public leaders. You'd hear people occasionally say phrases like, "The government is broken." And while people in Indiana said that, they didn't often say it about Indiana. I think that's because even acknowledging the multiple problems that need tackling, the many elements of Indiana government, under the most serious strain any of us can remember, have proven themselves capable of coming to terms with crisis. And so it has been with the men and women of Indiana's courts, who've proven themselves able to diagnose a defect or identify an opportunity, to recruit talented people and seize the moment on the basis of the best ideas available. challenges of the moment for the courts run an amazing range. Like, what do you do when somebody comes into the courtroom who speaks only Laotian? What can be done to cut the cost of litigation? How do we deal with the phenomenon of jurors using smartphones? How do we expand the new system of assessing the effectiveness of individual courts? How do we provide individual advocates for thousands of abused and neglected children? Are there better ways to regulate the lawyer advertising? How do we advance the cause of equal opportunity in the legal profession? How do we give a fair and full opportunity to the 2 million people who come to court every year when there's a 16% growth in filings, but only 4% more judges? The men and the women of Indiana's courts tackle all these issues and more, both through long-range strategic planning and through immediate action, and today I plan to report to you on 4 of those. The first is a genuine crisis on which all 3 branches of Indiana government have worked: mass mortgage foreclosures in residential housing. I'm sorry to tell you that foreclosure filings were up last year in 2010, even higher than they were in 2009. Now, Indiana is no longer at the top of the national crisis list, but that's not much comfort to the 43,000 new families facing losing their homes. You recently passed legislation giving every homeowner the right to ask for a face-to-face conference and the chance to negotiate for a modified loan. And the Indiana Foreclosure Prevention Network, led by Lieutenant Governor Skillman, and the lenders, and Attorney General Zeller, and the Housing and Community Development Authority, and the Division of State Court Administration have been perfecting the techniques that might maximize the chance that those conferences will lead to letting people stay in their houses. In the beginning, just 4 or 5% of the homeowners who received a notice for a possible conference replied that they wanted to do that. They simply missed it in the blizzard of paper that comes at you when there's a mortgage foreclosure filing. The judges who do this work discovered that if the court itself sends a separate notice, then more than 40% of the homeowners respond for a conference. And to make sure those work, we've assigned settlement facilitators to bring to the same table at the same moment the right people and the right documents. These facilitators tell us that many homeowners who come in for a settlement conference come in embarrassed, resigned, tearful. Some of them come in with their keys, thinking that this may be the moment of truth when they have to leave the house with nowhere else to go. But it doesn't always have to be. And in recent months, the system of court-facilitated conferences has been perfected to the point that the number of people who leave the room in those settlement conferences with a new loan is half of the people who come in for the settlement conference. And that's a tremendous improvement over where we were a year ago. We now use these techniques in counties that have 60% of the mortgage foreclosures statewide, and will expand them to the rest of the state before the year is out. We do all this without any claim on the state general fund, because you decided that it ought to be paid for by the people who use the system through filing fees on people who file mortgage foreclosures. It is a fluid situation, one that changes in the country and changes in our state. Just a week ago Monday, State Court Administration issued a best practices document, advice to all judges outlining case management improvements that maximize the chance that people might get to write a new loan. And Attorney General Zeller, who's taken a national position of leadership in the Association of Attorneys General on this issue, has asked the Supreme Court to use its rulemaking authority to reinforce these improvements. There is still need for additional legislation, and we've outlined our own ideas to Representatives Burton and Barden and Rican and Senator Talion, who've done so much work on this issue. As Governor Daniels said last night, criminal sentencing is an issue that needs addressing. You'll remember that a year ago, he and Senator Pro Tem Long and Speaker Bauer and Attorney General Zeller and I all signed the same letter asking that the Council on State Governments and the Pew Center on the States assist the Indiana Criminal Justice Evaluation Commission in a thorough review of our state's corrections. And just a few weeks ago, these researchers and the Indiana team working with them issued a set of proposals, and all the commission members, legislators, correction staff, prosecutors, public defenders, and judges endorsed them. You'll know from the press that the central idea of these proposals is to find a better way to sanction nonviolent offenders through stronger local corrections. Half of the new commitments to the Department of Correction are people whose crimes are in the least serious category, people who commit Class D felonies. I've handled Class D felons in my career as a judge. I've handled everything from a felony theft case for $6 all the way over to signing the order for lethal execution at Michigan City. In between those two polar opposites, making good decisions about which offenders are so risky that a prison bed is the only sound solution, and which ones can be treated adequately through local alternatives, makes all the difference in the world for public safety, for recidivism rates, for the employability of offenders, and for the dollars we spend on corrections. One of the weaknesses in Indiana's system has been that we've mostly used relatively outdated risk assessment tools to evaluate individual offenders. These tools organize and validate and help measure things that would be common sense anyway. Is this the offender's first offense or not? If there was a prior offense, was it a serious one or only a minor one? If the offender was on probation before, did he successfully complete it, or did he get revoked? Is there reason to believe that drug or alcohol treatment as a requirement might make a difference? So the question was, are we capable of creating a new way, a new assessment tool to help sort out who needs to go to prison and who probably doesn't? And the answer's been yes. And last Monday, a new generation risk assessment tool became mandatory in every criminal court and every delinquency court after we trained and tested 2,300 probation and corrections officers and drug and alcohol staff and judges in using it. The researchers from the Council of State Government told the criminal code team, their working group, that Indiana was doing a better job at this than any state in the United States. And I think that's a thing we ought to be proud of. Thank you. The package of sentencing reforms before you is based on reliable evidence, on actual experience. I think it's good for Indiana, and I join Governor Daniels in endorsing it. Now, if there's a place where Indiana's courts have proven themselves capable of identifying a problem or an opportunity, devising a plan to address it, and executing on the plan, it is technology. And I'm going to tell you about some recent examples. You all know that at your direction, every county in Indiana now uses a system built by our Judicial Technology and Automation Committee called JTAC to notify law enforcement immediately when a court issues a protective order on behalf of the victim of domestic violence. The question came, is there a way of giving them protection without having to make them trek to the courthouse? Answer, yes. And so we've now empowered 30 social agencies and 300 victim advocates to apply for protection online. Is there a way to notify victims of one of the most dangerous moments, the moment the abuser finds out the order has been issued? Answer, yes. And victims will soon now be able to receive immediate notice by text or email of this moment when they ought to be on guard. On another public safety front, the question has been how to enforce effectively the laws designed to prevent people who are certifiably mentally ill and dangerous from purchasing or possessing firearms. At your direction, JTAC has created an electronic system for notifying law enforcement immediately when someone is adjudicated mentally ill. Last week alone, the name, rank, and serial number of 39 people adjudicated mentally ill were transferred through the FBI so that police and gun dealers could do their part to keep firearms out of the hands of the mentally ill. And that system makes a difference. Is there something in the midst of a revenue failure that the judiciary can do to improve the collection of taxes? Yes. we've collaborated with the Department of Revenue to build a system for transmitting tax warrants straight from the Department of Revenue to local courts where the collection occurs. This time last year, 26 counties were using that system. Last week, we added Boone and Tippecanoe. Now there are 47 counties using it, and we recently issued the millionth electronic warrant for collection at the local level. Is there a way to stop handwriting traffic tickets so that officers can spend less time with a pen and more on patrol? Yes. And this time last year, 143 police departments were using JTAC's electronic citation and warning system. In the last 12 months, 60 more police departments have signed up. We'll be training people tomorrow in two very different places, a place called Lawsonville in Randolph County and the police department at Purdue University. Altogether, those now 200 agencies using an electronic method have issued more than 2.8 million citations that previously would have been written by hand. As drivers, it might comfort you to know that almost half of them were warnings and not traffic tickets. All of these solutions, well, yeah, I mean, it's a good thing. All of these solutions to these problems and others work ever so much more powerfully when they are connected to each other by a modern case management system we call Odyssey. Procured with your blessing 3 years ago through competitive bidding, we now use it in 77 counties, 77 courts, in 26 counties, from large ones like Marion to very small ones like Posey, accounting for nearly a third of the state's caseload. The power of the combination is something that judges and court personnel and law enforcement people see close up. And I want to tell you about an email that we got from a bail commissioner in Fort Wayne, where we're now installing Odyssey. He had a defendant who was out on bail for an offense in Fort Wayne. The offender was required periodically to report in, and he did on a given day. Here's what the bail commissioner wrote in his email. Defendant reported today on pretrial release. Checked Odyssey per normal supervision. Appeared defendant had felony probation violation warrant out of Huntington County yesterday. Huntington is also a place using Odyssey. Called warrants, he means the local warrants department of the Allen County Sheriff. Asked them to check IDAX, not on IDAX. It would have been, it wasn't yet. Explained to Rita the basis for my call. Had seen warrant on Odyssey. Rita called Huntington County directly. They reported they did in fact want the defendant. Did my typical stall until warrants showed up and took him into custody. That's somebody who'd have walked a year ago. Walked out on a warrant, a free man. And it is the kind of experience that leads to messages like the one we recently got from Hendricks County. When can you come and install Odyssey? The answer is we're doing it today twice as fast as we did it last year. We're working with clerks and judges in places like LaPorte and Shelby and Steuben County and 8 or 9 others. Just how fast we can get this done depends on how many people we can send to the courthouse to help the people in the courthouse who are actually going to use the system. And we managed to pay all of this with either federal grants or user fees paid by the people who use the system, presently $7 a case. We're asking that in this session, you will raise that fee to $10 temporarily, fall back automatically by operation of law so that we can speed up and get to the 175 courts who've asked us to come and install Odyssey, because it will make happen things like the thing that I described that happened in Fort Wayne. The House voted to do that in the last General Assembly, and the Senate Judiciary Committee did likewise by a vote of 9-0. All of these achievements are the result of collaboration between the judiciary and agencies like the Indiana Office of Technology, the Bureau of Motor Vehicles, the Department of Revenue, the Criminal Justice Institute, the state police. None of them could have been accomplished by the judiciary alone or by anybody else alone. Does this matter to citizens? Does it make a difference to the people that you and I both work for? Well, the answer to that is, if you build it, they will come. And the fact of the matter is that rather than driving to the courthouse or hanging on the telephone Our constituents were seeking court information this morning through Odyssey at the rate of more than 3,400 an hour. I'm proud of the fact that Indiana is well on the way to creating a 21st century case management system that our citizens can use to do the things they have to do in our county's courts. Now, as for making the legal system easier, let me mention something we finished just a few months ago. People come to the courthouse every year by the tens of thousands to make possible that jewel of the Bill of Rights, trial by jury. And during those trials, judges and lawyers explain to them the law that applies to the case the jurors are being asked to decide. Too often, we've explained it to them in legal jargon. Committed to doing a better job, the Indiana Judges Association began work on what we decided to call plain English jury instructions. A drafting committee led by Judges John Para of Lake County and Carl Held of Evansville, and an English teacher to boot, spent 3 years revising these classic instructions. I'm going to give you just one example. It's one that happens all the time. What's the difference between direct evidence and circumstantial evidence? Here's what we would have said before. We would have said, we looked at the jury and we would have said this. Direct evidence means evidence that directly proves a fact. I'm sure that was helpful. Without an inference, and which, if true, conclusively establishes that fact. Circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn, and so on and so on. Right. New version. Direct evidence that an animal ran in the snow might be the testimony of someone who actually saw the animal run in the snow. Circumstantial evidence might be the testimony of someone who only saw the animal's tracks in the snow. I suggest to you this is a better way to try people what the nature of what it is they're supposed to be doing. They didn't cover that at Georgetown, I guess. Now, we think some of these are successful, but what do people in our business on the outside looking in have to say? Well, on jury instructions, for example. The Chief Justice of a large southern state called last fall to say they had decided to do something about jury instructions, and they consulted with experts in the field, and the experts had told her, call Indiana. The chief judge of a large federal court in the north called to say he was thinking about allowing jurors to ask questions during a trial. Nobody in federal court in that city had ever done it before, and he'd heard that Indiana did this the right way. I explained to him what we do, and I sent him to Judge Bob Altice of the Marion Superior Court, who does this all the time, every day. The Council on State Governments gave JTAC's project called Insight an Innovation in Government Award. The Kennedy School gave its work on e-tickets what they call a Bright Idea Award. Judge Greg Donay of Lafayette won the nation's highest honor for devising ways to help citizens who have to navigate the legal system without a lawyer. The American Bar Association said that our Courts in the Classroom project on civics was the best in the United States. On substantive law, the Chief Justice of a Western state stopped me at a conference to say that the members of his court had debated at length whether to agree or not embrace an opinion on medical expenses written for our court by Justice Sullivan. And a leading national expert on alternative criminal sentencing, a retired judge from California, told me that Justice Dixon's opinion on the use of risk assessment tools in sentencing was simply the best piece in the country on that subject. And Judge Kirsch's opinion on robo-signing, written for the Court of Appeals, robo-signing in mortgages, has been cited all over the United States. In short, Indiana's judiciary is one that keeps its feet firmly planted on this territory, on Hoosier soil, while keeping its eyes on the horizon. They are men and women of high ambition, capable of confronting a problem, designing a plan, and executing on the plan. I'm proud to be their colleagues because that's the kind of people who work with us. Why does that matter? in the daily life of our state. It matters first because whether we can build a better system of justice, it matters first and foremost to the individual citizens who come to court as part of the 2 million cases we hear every year. Our first duty is to give them a full and fair hearing. But whether we run a respectable court system matters for people who've never seen the inside of a courtroom, because a reliable court system is part and parcel of a decent government and a crucial element in a healthy and productive economy. There is a moral dimension to our duty to our fellow citizens as judges, but I was refocused on the economic connection driving to work last week. I heard a radio interview with an author of a new book on the economic miracle of modern India. The interviewer asked the author about what he called the differing narratives of India and the United States. The United States, said the reporter, has always thought of itself as a place of unlimited future opportunity, and now pauses to wonder whether that will always be true. India, by contrast, held back for decades, if not centuries, by caste and class, is now written about every day as the wave of the future. He could have just as well been speaking about India or China. Is India, the reporter said, the new land of opportunity? Well, you're right about the storyline, said the author. That's what we read in the press. It's what we read on television. But in both countries, we overplay the storyline of the day and underemphasize the fundamentals. Here's how he described that. In America, you take something like American universities, for example. You take the Silicon Valley phenomenon. You take the way the American legal system functions. These are century-level advantages for America. It will take other people a very, very long time to replicate any of these, much less replicate all of them at the same time. In short, the message was that if we do what it lies within us to do, places like India and China aren't going to catch Indiana for a long time to come, and I promise you that we are building a court system that does its part to make that happen. And that is the state of your judiciary. Thank you all very much. Thank you. Thank you all very much. Thank you. Yeah, thank you. Thank you very much. Thank you very much. Thank you. Thank you. I'll step behind you.
This joint assembly is adjourned.
And before we adjourn the House, we omitted one introduction. We have Federal Court Judge Tanya Walton Pratt is with us in the balcony. Judge Pratt. Congratulations and thank you for being with us. Is there further business to come before the House? Chair recognizes Representative Harris for a motion.
Mr. Speaker, I move you that we now...
Is there a second? All in favor indicate by voting aye. We are adjourned.